Ani sanibonani, ninjani, molweni, afsheni, tobelanda. Guys, today is sem2 the best tutor you can have on your side. Today we have Scl1501 assignment number 1 to end semester 2024, and we have a 50 marks questions, 50 marks which we have to be answering, and in order to pass this one, it's a compulsory this assignment. So let's start with question number, which one? Questions are easier, but we'll answer all the questions anyway. So let's start with question number 3. Yeah. So question number 3, number 1, what are leading questions? At which stage in a trial should they be avoided? Number B, at which stage of the trial is cross-examination conducted? In your answer, you should also state the purpose of cross-examination. So now we are going to talk about cross-examination and leading question. Why? Because it's one thing. Cross-examinations and the examination in chief. So we are going to be talking about those things so that you understand. We'll be talking about examination in chief, cross-examination, and re-examination, so that you're able to understand about the leading questions, right? Back in the days when CSL was still CSL, we used to have a write assignment like this. This one was in 2019 when I was when I was doing CSL. It was a very good module, intriguing module, because we used to have a part B. Where after answering the question, you have a part B. I will show you part B. I think that yes, this one, part B. We used to have a part B of a court observation. When we do CSL that time, we used to go to court, to observe how court, what is transpiring in court. They said that this part of assignment requires you to visit a court of law, whether it's magistrate or high court in your area, and attend a real court case to make observation. So you have to be studying unit 4, 5, so that you go knowing, and the Legal Practice Act, because it's the one that is the foundation of a legal practitioners. So it's a guideline for legal practitioners, a Legal Practice Act. So you must know it. We used to go, and then they have to talk about, that we must make arrangement with the clerk or with the register of the court. So you will go to court, you will write your name and student number, the court that you have attended, the date, the duration, the type of case that you attended, whether it's a civil or criminal, and you explain above the parties who were involved. Now, the most intriguing party that I want to show you is that we used to have an opening address. What was the who opened at the address? Then we are here. We have examination in chief and cross-examination. So you must know what happened during the cross-examination and examination in chief. Now listen to me very carefully. In the examination in chief, when you go to court, you go with your witness. When you arrive in court, you will examine your witness. We call this examination in chief. Now, remember, you examine your own witness. On the other side, the state will come with their own witness and examine them, right? After examining them, both of you are right with your witnesses. Then you go to the second stage, which is the cross-examination. Cross-examination, it means you will swap the witnesses, right? The state will take your witness and examine them, whereas you will take the state witness and examine them. Now let's go to read about much so that you know how to answer. Now let's start with the examination in chief, the one that I'm telling you. The purpose of examination in chief is to present evidence favorable to the version of the party calling the witness, just like the way I was explaining to you. The method mostly frequently adopted in the question and answer technique. Then we have a leading questions. They say leading questions generally prohibited. A leading question is one which either suggests the answer or assumes the existence of certain facts. which might be in issue. The reason for the prohibition of leading questions is that the witness might be favorably disposed to the person calling him and readily adopt the suggested answer. Right? So let me go to others that summarized very well. The most important thing to be a lawyer is to able to do a research, right? Research is a very basic for a lawyer. So examination in chief, who conducted it? It is conducted by party who calls the witness, just the way I explained. The purpose of examination in chief is to put relevant and admissible evidence before the court by making use of the question and answer method. Questions. Leading questions may generally not be asked during examination in chief. Leading question is a question which assumes the existence of a dispute fact or which suggests the answer. A leading question may be asked on facts which are not disputed, where it is considered necessary to save the interest of justice or to expedite the proceedings. The court has a discretion to allow leading questions. Questions may not be asked during regarding the witness' bad character or previous conviction. So what I was trying to say is to remember why I started with the examination in chief. I want you to understand so that when we go to cross-examination, you know about the leading questions. You know about the leading questions of the examination in chief and leading questions in the cross-examinations. So that when you answer the question, you answer with more facts, and more information. So here you have learned that the leading question cannot be asked. What is a leading question? Leading question is a question which you answer by saying no or yes. For example, did you eat today? You will just simply say yes. In the examination in chief, you are not allowed to ask that question. So rather you will say, what have you eaten today? So the person will explain that today I have eaten food. If you have eaten, if you have not eaten, no, today I have not eaten. Rather than saying did you eat, you understand? So it's not allowed to say did you eat. You have to ask in a way that the witness will give more information. Okay, now let's move forward to the cross-examination. Now let's move at the cross-examination. A cross-examination is a fundamental procedural right. It is one of the essential components of the accusatorial or adversarial trial and a natural and integral part of our trial system, where emphasis is placed upon orality. Cross-examination is the name given to the questioning of an opponent's witness. It succeeds examination in chief, right? The essence of any defense should, in principle, be introduced during cross-examination. Now, failure to allow cross-examination constitutes a gross irregularity. The court has no right to prevent cross-examination, even if the purpose is to protect the witness. What are the purpose of the cross-examination? The purpose of cross-examination is to elicit facts favorable to the cross-examination's case and to challenge the truth or accuracy of the witness' version of the disputed events. The scope of the cross-examination is wider than of examination in chief. The cross-examiner is also not restricted to matters covered by the witness. So let's go to the leading questions because this one is very important. Leading questions may, as rule, be asked in cross-examination, but there is a measure of a dispute as to whether leading questions may be put to a witnesses who are obviously favorable disputes to the cross-examiner. So here you learn that in the cross-examination, they can ask the leading questions, which may be answered by yes or no. So in brief, you can say a witness is cross-examined by the opponent of the party who called him after having given evidence in chief, which we call cross-examination in chief. The purpose of cross-examination is to elicit evidence which supports the cross-examiner's case, to cast doubt upon the credibility of the opposition party's witness. And we learned that a witness may be asked a leading questions, right? Then we will conclude by re-examination. Re-examination follows cross-examination and is conducted by the party who initially called the witness. A party has a right to re-examination. And then we have a purpose there. Okay, let's summarize. So in summary, we can say that after cross-examinations by the opponent, the party who originally called the witness may re-examine him. The purpose is to enable the witness to clear up any misleading questions. Leading questions may not be asked. So this one is the same as the cross-examination in chief. They don't ask leading questions. So let's go back to the assignment, and we have answered what are leading questions, where leading questions should be where in which stages of the leading should be avoided, and we said in the examination in chief and in the re-examination, and we said that they can be asked in a cross-examination. Now you know this thing, you are going to totally pass. Number B, at which stage of the trial of cross-examination? We have talked that is a second stage after examination in chief. Then it follows by cross-examination. Then we talk about the purpose of cross-examination. It means that these 5 marks to you now is very simpler. You must not forget that the video contains a well-researched educational information. Unfortunately, we cannot share all information public. This is in line with the African or indigenous law of nothing for Mahara. The full video are available on my channel for 100 Rand fee monthly. 100 Rand fee allows you to watch all assignments videos. Once you pay our fee, it means you are eligible to request documents used in this video and other videos as well. So you don't ask us about the documents if you are not on our monthly fee. And another thing is that if you don't see a video on our 100 Rand fee, please let us know on our WhatsApp 061 984 2135. And then we are moving forward to write a paragraph in which you explain the difference between the following: state attorneys and the state advocates. And then we are going to talk about the register of the High Court and the clerk of the court. This one is easier, the register and the High Court. I think that you will just go to learning unit 5. Then you come to the clerk of the court and the register. Then you summarize. It's up to you how you summarize it. It's a very quick one. It's very easier. They do the same thing. It's just that they differ by court. In High Court, it's called the register. In lower court, in magistrate, they call it clerk of court. But they do the same thing. They do administration, those guys. So yeah, let's move. And then you'll come here and then just summarize the state advocate and then the state attorney. Remember, the state advocate is called a prosecutor or a public prosecutor in magistrate court. When the case goes to High Court, we call it public prosecutor, a state advocate. That's the difference, but they're the same. And then this one, state attorney, is only the person who represents the government departments. So that is the difference. So you will come here and differentiate yourself. We have more things to do in assignment rather than this quick one. Then question 4, differentiate between a majority and minority. Here on the unit 3, you will see majority and minority. So you will come and then summarize for yourself. I don't want much to deal with something that you can actually summarize yourself. It's not a bigger thing, this one. Now let's start with a question number 5, which is the best question for the day. Question number 5. Peter purchased a Mercedes-Benz ML350 last week for 750,900, VAT included. While driving from Bendo Park in Polokwane, he collides with Ken of Regime Removals, who is the owner-driver of Porsche Cayenne. Peter is 25% negligent, whereas Ken is 43% negligent. The damage to the Porsche is estimated at 120,000. It is uneconomical to repair the Mercedes-Benz, but its salvage value is 2 or 5,000. The pre-accident value of the Mercedes-Benz was 6990000. Okay. Remember here we check the negligent first, then we check the estimated, then we check the salvage, then we check the pre-accident value. Then we answer this question with reference to the damage to Peter and Ken's motor vehicle. Calculate who must pay who and who will be the amount in damages. On my channel, go to join and choose 100 fee monthly, which will allow you or allows you to watch all your assignments, modules, and learning. Thank you. Do that and you'll find all the calculations and how we answer other questions there. Good luck, guys. It was a CSL. It's up to you whether you are joining us or not.